Get ready for the dictation. On the count of 3, 2, 1, start. The appellant filed its statement of defense referring to clauses of the agreement to demonstrate that all the claims raised by the respondent were contrary to the contractual clauses which had been voluntarily and consciously agreed upon by the respondent. The appellant had also filed an application under Section 16 of the 1996 Act before the arbitral tribunal contending that the claims made by the respondent were barred by limitation. The arbitral tribunal rejected the said application by an order dated 17/1/2009. The arbitral tribunal pronounced its award on 12/3/2013, dismissing claim numbers 1, 4, and 7 of the respondent and partly allowing claim numbers 2, 3, 5, and 6. The appellant submitted that the findings of arbitral tribunal which have been upheld by the LD single judge were contrary to the specific clauses of the agreement entered into between the parties and were therefore irrational and perverse and against the fundamental public policy of the land. The claim-wise findings of the LD arbitral tribunal are as follows. As regards claim number 2 towards cost compensation for well point system for dewatering, the arbitral tribunal awarded an amount of rupees 58,61,222 against the claimed amount of rupees 60,61,221. The arbitral tribunal found that by executing the work from the bridges as the groundwater table was high and the site of the work was situated within irrigated area with the founding strata consisting of silt and fine sand creating adverse subsoil condition, it could not be possible for the contractor to control seepage and groundwater flow by conventional dewatering method of excavating a pit or trench deeper than the foundation level, dug beyond the foundation pit, and engaging pumps or adopting similar measures. As such conventional methods of dewatering could result in collapse of the foundation trench, endangering the safety of the existing bridges, traffic, men, materials, and machinery working in the site, and therefore the contractor adopted the well point technique of dewatering for the laying of foundation of these bridges. The arbitral tribunal found that the subsoil condition could not remain same and static permanently, and it was quite likely that the changes might occur with variation in rainfall, lowering of groundwater level, minor irrigation, and such other measures taken. A difficult situation with regard to pumping and dewatering in excavation of foundation might always arise and could not be foreseen beforehand with the precision and more so with visual inspection of the site, and the correct assessment could only be made after excavation of the foundation trench, and the contractor could not ascertain the magnitude of the problem before doing this exercise. The arbitral tribunal also held that in clause 304.5 the contract unit rate for item of excavation of the structure did not provide for particular and specific system of dewatering by well point system, which is a specialized kind of work requiring adequate compensation accordingly. The arbitral tribunal found that in this clause in contract unit rate provision has been made towards compensation of operation for dewatering including pumping, which is of general nature requiring no particular skill or expertise. The learned single judge has upheld these findings on the ground that the same cannot be said to be perverse, contrary to the provisions of the Act, or contrary to the evidence placed on record. The appellant submitted that the following provisions of the contract would show that the findings of the arbitral tribunal are completely in contravention of the contractual clauses. The appellant submitted the single judge ignored the specific amended clauses 2104.1 in most specification for road and bridge work, which provide that open foundation shall be constructed in dry conditions and the contractor shall provide for adequate dewatering arrangement to the satisfaction of the engineer.